Good morning, guys. Today we're going to discuss rescissible contracts. A contract is rescissible when one of the contracting parties suffers or a third person suffers lesion or damage. So, the following are considered to be rescissible contracts. Number one, those that are entered into by the guardian when the ward suffers lesion or damage by more than one-fourth of the value of the property. So let's say, for example, your parents died, and so therefore the court appointed your uncle to be the guardian since you are a minor. So to support your education, the uncle decided to sell some of the properties. And one of the properties sold has a fair market value of 500,000 and was sold only for 300,000. So in other words, it's 200,000 short of its fair market value. So if we are going to compute for how much is the damage percentage of the damage, that's 200,000 divided by the fair market value 500,000. That gives us a 40% damage or lesion. So it's already beyond the 25% or one-fourth of the value of the thing. So you can have the contract of sale entered into by your uncle together with the third person rescinded when you reach the age of majority. Alright? So the second one are those that are entered into in representation of the absentee when the absentee suffers lesion or damage by more than one-fourth of the value of the property. So the same with that of the guardian ward situation, it's one-fourth. So let's say, for example, you have been absent, you can nowhere be found or located. So one of your relatives decided to sell one of your properties to support your children. So the property has a fair market value of 500,000 and was sold for 300,000. So in other words, you suffers lesion by 40%. Okay, so which is already beyond the 25% of the one-fourth of the value of the property. So when you appear, you can have the contract of sale by your relatives with that of the third person selling your property rescinded because you suffer lesion by more than one-fourth. Alright. The third one are those that are undertaken to defraud the creditors. When the creditor cannot in any manner collect the claims due to them. So the law provides what are the situations that are considered to be in fraud of the creditors. The first one is gratuitous alienation are presumed in fraud of creditors if the debtor did not reserve sufficient property to pay all debts contracted before the donation. Okay. So, let's say for example, you owe me 100,000 and your only asset has a fair market value of 150,000. Right? The problem is you donated the only property which has a fair market value of 150,000 to your father-in-law. So you don't have enough properties now that I can run after for the satisfaction of my debt. So the law said it is presumed to be in fraud of creditors because you did not reserve sufficient property that is for the satisfaction of your obligation. The second situation that is in fraud of the creditors are those onerous alienation when made by person against whom some judgment has been rendered in any instance or some writ of attachment has been issued. So let's say, for example, you owe me 100,000. Then for several times I made the demand. Still you did not pay. So I filed the collection case in court and petitioned the court to issue a writ of attachment. So the court issued the writ of attachment. So when the court issued the writ of attachment, what you did is you sell your only property with a fair market value of 150,000 to a third person. So in this case, the law said this is considered to be in fraud of creditors. Alright? So the fourth situation, the fourth rescissible contract are those things under litigation when entered into by defendant without the knowledge and approval of the litigants or of the court of competent judicial authority. Okay, so let's say for example, a parcel of land is now contested by you and me. So you claim that you are the owner, and I claim also that I am the owner. So there is now a case pending in court for the settlement of who is really the real owner. But you are in the possession of the land. So because of the problem created by this litigation, you decided to sell this land that is the subject of the litigation to a third person. So what can I do? I may petition the court to rescind the contract that you entered into selling this parcel of land that we both claim as owner. Alright? The fifth one are all other contracts specially declared by law to be subject to rescission. So what are these all other contracts that are declared specifically by law that are rescissible? Number one, sale in case of breach by seller of warranty against hidden defects. In other words, sale of things with hidden defects are considered are declared by law to be rescissible. Another one are sale of animals with redhibitory defects. Under the the law on sales, when an animal is sold with redhibitory defects, the contract is rescissible. Another one are the contracts of partition. When one of the heirs receive things whose value is less than at least 1/4 than the share to which he is entitled. So let's say for example, there are only two of you who can inherit your parents, and your inherit the property of your parents, and your parents died. You inherited the car, your other sibling inherited the house and lot. The house and lot has a fair market value of 1.5 million. Your car has a fair market value of 500,000. So if we total the 1.5 million and the 500,000, that's a total of 2 million estate. So it should have been divided equally. If it is divided equally, you are entitled to receive 1 million, not 500,000. Since you inherited the car, which has a fair market value of 500,000 only, then what you inherit is short of more than 1/4 of the value that you ought to receive. And so the law will declare the partition to be rescissible. So you can have the partition rescinded. Okay? The last one are those payments made in the state of insolvency for obligation to whose fulfillment the debtor could not be compelled at the time they were effected. So let's say for example, your assets has a total of 200,000. You owe me 100,000. And you owe X 150,000. Alright? So, your total liability therefore is 250 when your total assets is only 200,000. Okay? So, The problem now is that you paid X, the 150,000, even if what you owed X is not yet due. But you did not pay me the 100,000, which is already due. So the law said it's a contract that is rescissible. Alright? So what is the status of a rescissible contract? Rescissible contracts is considered to be or are considered to be valid until it is rescinded. However, the law said this is a remedy of last resort. It simply means that when there is no other means to recover or that can be availed of, um, then this is the last remedy that you can avail. However, if there are other remedies that you can still avail, you cannot ask for a rescission. So what is the effect if there is rescission? The parties will be bound to return whatever they received by way of the contract that they received to each other because of the contract. So, however, it must not be legally in the possession of a third person who acted in good faith. So when can you rescind the contract? The action for rescission must be brought within 4 years. Number 1, from termination of incapacity of a person under guardianship. So, let's say for example, in the case of your uncle, since you are 15, then you can brought the action for rescission 3 years after you attain the age of 18. Alright? Number 2, 4 years, within 4 years from the time the absentee's domicile is known or located. And number 3, within 4 years from the date of the contract for all other cases. So, from the third, fourth, fifth, and sixth situation. So, what is the extent of the recovery under rescission? Rescission shall only be to the extent necessary to cover the damages caused by the contract. So these are the important things that we need to take note, guys, in the rescissible contracts. See you on the next video on budgets of fraud in relation to contracts to defraud the creditors. Bye, guys.